Nice to see you all. I'm John Goldberg, the interim dean here at Harvard Law School, and thanks for coming. I would say normally late February you'd rather be indoors than anywhere, but you're actually decided to come in from what counts as a beautiful sunny day here in Cambridge, so thank you for coming. This is our first Rappaport Forum of 2025, and I'm really excited about it. As many of you know, the forum was launched back in 2020 as a locus for full, vigorous, and civil discourse on complex and challenging issues facing our community and our nation and our world, and that I'm sure is what we're going to have today. Funded by the Phyllis and Jerome Lyle Rappaport Foundation, this event honors its namesake, Jerry Rappaport. Back when he was a 1L here at Harvard in 1946, Jerry established the original HLS Forum. And I want to thank the foundation for supporting this vital effort. As Jerry once put it, quote, to model a process that is core to our democracy, unquote. I also want to recognize today and thank Amanda Teo, who is here today from the foundation, signaling its continued support. Welcome back, Amanda. I'm going to introduce our moderator in a moment, but I did want to first say thank you to our panelists, Professor Chander and Rosenstein, for joining us today. Excuse me. They will be more properly introduced in a moment, but I'm really grateful to you both for sharing your expertise and perspectives on this important topic. I also want to thank some of the many people who helped organize this event, including my wonderful colleagues and deputy deans, Molly Brady and Glenn Cohen, our Rappaport fellow, Isaiah Ogren, and from the Dean's Office, Liberty Keneally and Catherine Cronin. Please join me in thanking them for all of their efforts. Our moderator today at the far end of the table, as you all know, is Professor Jonathan Zittrain, or JZ, as he is affectionately known in many circles. He is the George Bemis Professor of International Law at Harvard Law School. He is also a Professor of Public Policy at the Harvard John F. Kennedy School of Government, a Professor of Computer Science at the Harvard School of Engineering and Applied Sciences, the Vice Dean for Library and Information Resources, and, if that is not enough, co-founder and faculty director of Harvard's Berkman Klein Center for Internet and Society. Perhaps more importantly than any of those fancy titles, he is a beloved teacher, treasured mentor, groundbreaking scholar, and wonderful colleague to all of us who have the good fortune to work with him. Under Professor Zittrain's direction, the Berkman Klein Center has been a gathering place for experts in multiple disciplines to identify potential solutions to complex technological policy issues relating to cybersecurity, AI, and online disinformation. The center has also launched the Institute for Rebooting Social Media and the Applied Social Media Lab, which work in tandem to improve how we learn, debate, and coexist online. Professor Zittrain also has championed the development of the Case Law Access Project, which has expanded free public access to U.S. case law. A member of the American Academy of Arts and Sciences and the board of the directors of the Electronic Frontier Foundation, Professor Zittrain is the author of many, many books and articles, including one that I hear is almost upon us. Honestly, I can't think of anyone who is better qualified to lead today's discussion on TikTok and free speech. So please join me in welcoming our panel and Professor Zittrain.
Well, thank you so much, Dean Goldberg, and thank you so much, Professors Rosenstein and Chander, for joining us today. It's hard to think of two better people in the world to talk about the topic we have in front of us. So just so glad you're here, and there's so much to slice and dice here. So I would just love to jump right in. And we have, I guess as statute, if not operational law, the Protecting Americans from Foreign Adversary Controlled Applications Act, otherwise known as the PFACA. Is that right?
What I would give for a backronym.
Yeah, it's so the PFACA. That's better sounding. The PFACA is addressing some problem that was deemed big enough that it had bipartisan support, which is how it got passed, Democrats, Republicans together. And I guess it might be right to ask you, Alan, to just open with what problem you see this statute as solving, and understanding that it might not be exactly what you would write if you had root access to the US code, but why, on balance, you might be of the view that it's pretty good.
Sure. And first of all, thanks everyone for coming and for having me here. It's nice to be back. I can't keep saying PFACA. It's so awkward. I'll just call it the TikTok law. So the TikTok law was enacted for two reasons, and I'm drawing here from the statements from the legislation itself and the statements made by its supporters. One having to do with data privacy, and the other having to do with content manipulation. So everyone here is familiar with TikTok, likely also know that it is controlled by ByteDance.
It's about, what, 160 million US users?
170 million.
170,
Yeah,
10 million just in the past little while.
Yeah, exactly. It's a very, very popular platform.
Can I just ask, how many people would consider themselves routine users of TikTok? All right, I'd say about a third to a half. How many people are using TikTok right now? Okay, just a couple. Thank you. All right, back over to you. Sorry.
And so TikTok, which is owned by ByteDance, and ByteDance ultimately a Chinese company that's subject to the whole panoply of Chinese law, including national security law. And the concern is that because of that, that opens up the possibility of Chinese influence that could be very harmful to the national security of the United States in two ways. One is through the harvesting of a huge amount of information on TikTok's 170 million users, and the use of that for all sorts of counterintelligence purposes. Countries around the world and their intelligence agencies are always very interested in the personal habits and interests of as many people in target countries as they can. That's going to be very useful, whether for blackmail or for cultivating assets. And then the other concern is around content manipulation. TikTok, as again, those of you who have used it know, and really the reason why it burst out into the scene and became so popular so quickly is that it is almost entirely algorithmically driven, which is to say you log onto TikTok as a new user, you watch some videos, you thumbs up some, you thumbs down others, and then TikTok's special sauce, as it were, is that its algorithm is very, very good at serving you what it thinks that you will like, and given that TikTok has 170 million American users, clearly that algorithm is doing something quite well. That algorithm, like all these algorithms, is a black box. Users and really the outside don't understand how it works. And because of that, the concern from Congress was that the Chinese government, through ByteDance, could pressure TikTok to modify that algorithm in a way that would be averse to America's interests. So imagine that the United States and China get into a shooting war over Taiwan. Suddenly, the concern would be that TikTok would be flooded with pro-Chinese, anti-Taiwan, anti-American content. And given that TikTok's not only very popular, but for young Americans, it is increasingly not just a source of news, but the main source of news. The concern there is that just as the United States would not have allowed the Soviet Union to purchase CBS in 1960, the United States did not want a Chinese government having influence over one of the main information platforms in the United States.
Got it. All right, thanks for that tight TikTok length capitulation of the situation. Anupam, over to you. I think you're skeptical of the problem and the need, and it also might be worth talking a little bit about the solution that the law introduced.
Sure. So first of all, the problem, and you'll note that in Professor Rosenstein's description, the problem was all speculative. It was the possibility that we might get into a shooting war. They might then use the app to manipulate us in favor of China, neglecting our sense of patriotism, undermining democracy, et cetera. Or they might convince us that Taiwan is really Chinese and therefore should properly belong to China. Those are the kinds of highly speculative things that First Amendment law typically has not tolerated. So we've seen a lot of speculation in the past. The Pentagon Papers case, there was speculation. The government literally told the Supreme Court, if you publish these papers, soldiers will die. That was the speculation in that case. And the Supreme Court said, you know what, we don't think that is enough, you have enough evidence of that. It's too speculative, too remote to justify this massive intervention that suppresses speech. Now the government has told us, and the Supreme Court actually has said, potentially, that there's no First Amendment case at all. It's not, the First Amendment is hardly even implicated in this case, because this is a neutral law. This is a content neutral law. It's simply talking about ownership, just like an M&A law. Okay, you have M&A laws all the time, and therefore we tell you divest because you can't have so much concentration. That's what the Supreme Court has said, and maybe, therefore, there's no First Amendment issue at all. That's what the government argued before both the DC Circuit and the Supreme Court. And in this case, by the way, the Supreme Court, in its unanimous decision, though there's the unanimous judgment, I should say, does not actually, says, we'll apply heightened scrutiny, but we're not even sure that it needs to be applied. Okay, so just imagine the situation we're in where Professor Rosenstein's description, which was very much about the possibility of two things, as he said, espionage and propaganda. Okay, propaganda being exactly the kind of, what is propaganda? Speech of people you don't like. Okay, so literally it's, unwanted, disfavored speech in the American polity. Congress, working with the president, can now say that speech can be suppressed, and it evades First Amendment review. That seems quite problematic. And so we should be a little bit nervous when we are in this, the Supreme Court puts itself in this mode. Now, it does so under incredible duress. So with a factual record, the Congress has placed the only challenge to the law's application can be brought only in the DC Circuit Court of Appeals, which is not very good at fact-finding, to say the least, and there's no fact-finding in the case. So there's just some affidavits thrown from both sides, and there's a House report. There are no findings in the law itself. The law passes through the House in a week's time. It's then appended. So, Professor,
it's not like the careful, deliberative work of Congress that we've come to love and expect. This is an exception.
That's a fair point. It's maybe perhaps par for the course, but here it's then the Senate refuses to pass this law. The House passes it in March. The Senate refuses to pass it, refuses to move. But the House is unwilling at the same time to pass Ukraine and Israel funding. And so to get the Senate to pass the TikTok law, the House engineers yoke the two bills together, pass it again, the TikTok law as part of a larger military aid package, and the Senate speeds it through. So it is bipartisan, but it's a kind of compelled bipartisanship that should make us a little nervous about what it actually signifies about the way that Congress went about this.
So two quick questions on that so far. One, is it your view then that the circumstances by which Congress passes a law are fair game for judges to review in deciding how much to credit whatever factual predicates Congress included as the basis for the law?
So I think so. So this is a great question about legislative interpretation, constitutional interpretation, and we certainly have in the room some of the leading figures in that domain. But the Supreme Court repeatedly cites the House report. So it says the House made these. It calls them findings when normally you don't think of a House report as findings of anything. And so it says there are findings here when there aren't any findings. And then the DC Circuit dismisses as, quote, stray remarks the statements of members of Congress. And so when members of Congress say exactly their unconstitutional purpose explicitly again and again and again, and then the DC Circuit says those are just stray remarks, but those were made by the very sponsors of the law, not just by one of the 535 who happened to vote along with it. It's in the statute, it's in the House report, it's in the first time they introduce this bill, it's in every time that they discuss why the bill should pass, and any retrospective explanations of the law. So we have a kind of the Supreme Court doing a runaround, effectively erasing one of the key pillars, telling us that this law would have passed on the other pillar alone, with this counterfactual that is very hard to actually defend in the face of the facts.
And second question before turning back to Alan, you made reference to the prospect back in the day of the Soviet Union purchasing CBS or some of the homegrown newspapers maybe in a given metropolitan area. Do you think, by contemporary standards, a law precluding the Soviets from buying up and operating those things would be contrary to the First Amendment?
To me.
Oh, no, I was going to ask Anupam first.
Okay. Oh, sure. Okay. So
think I know where you're going.
we have said broadcast television must be regulated because it must be licensed. You can't have two people, and this was.
That's why I said newspapers.
Oh, newspapers. I'm sorry. Okay,
I
newspapers.
moved from the
sorry.
CBS to-
Okay, sorry.
Yeah.
Okay, so let's go to the newspaper. I don't think you could constitutionally ban the New York Times from. I don't think that Congress could pass a law that the New York Times had to change ownership. Okay. And so the government argued in this case repeatedly, we're only talking about a change in ownership. You can keep on saying pro-Chinese propaganda. But now imagine that hypothetical in the context of the New York Times. We're just causing you to change ownership, New York Times. You can still keep on saying things against the current administration as much as you want. Okay? That would be a nonsensical claim, but yet the government made it in this case. Now, why do I choose the New York Times for this hypothetical? Well, at one point, the largest shareholder in the New York Times was a foreign national. And we could be, in the future, to speculate, just like Alan did, at war with Mexico, apparently. We have always been at war with East Asia. And who was that person? He was Carlos Slim, the Mexican billionaire. So could we say, because it's owned by Carlos Slim, we can no longer trust the New York Times, not for the propaganda, this is what the Supreme Court said, but because it might hoover up data, and because it's under the control of Carlos Slim, turn it over to the Mexican government with whom we might be in the future, in a future shooting war with.
You would think that's, no matter how well grounded, you'd think that should be contrary to the First Amendment, that worry.
Absolutely. And we saw this in the 1960s with the Lamont case, which is the first case ever by the Supreme Court.
This is Lamont versus Postmaster General.
Lamont v. Postmaster General in 1965, in the middle of a shooting war, an actual shooting war, where the Supreme Court says, hey, when Americans want to get Chinese propaganda, literally the Peking Review number 12, they are entitled to have it without the government interdicting it in the process. And so we have a right to receive foreign propaganda.
And that wasn't even interdiction, was it? It was you could opt in to get you could go to the post office and fill out the I would like communist propaganda form and then get all the...
Exactly. So we've said that we have this constitutional right to receive foreign propaganda. And so I think the propaganda...
And the duty, really. No, sorry.
That's why the Supreme Court ignores that it doesn't want to go down the propaganda line, so it rests its holding entirely on the espionage angle.
So Alan, Anupam is all in. He's all in on this, and extremely passionate, well argued. Are you persuaded?
I am not persuaded. But I should say, I have always argued that the law is constitutional. For whatever reason, the 12 judges who looked at this, 3 at the DC Circuit and 9 at the Supreme Court, seem to agree. That doesn't
see what
mean
you did there.
that doesn't mean that I'm right. Anupam has truth, justice, and the Constitution. I have 12 judges, so I don't know. You can all figure out how that balance goes. But I don't like the law, and so I think I am at a bit of a disadvantage in that I don't think I'd ever be as full-throated of a supporter of the law as Anupam is a critic of the law. I think it's a terrible law. I just think it's, given the situation, given the reality, probably the best thing that the United States can do. So I think rhetorically, I'm always going to be a little bit more sort of in sorrow I come to defend the law. But I will
wait, it does
defend
sound
the
like
law if I
maybe you
need
would
to.
have voted for the law.
Oh, I definitely would have voted for the law.
Okay, you don't
I would
like
have
it, but you would have
Oh yeah, I would
voted
have
for it.
100% voted for
All
the
right,
law,
great.
but I
Just
would
good to
not have
clarify.
enjoyed that process at all.
Yeah.
And I would have wished that Congress had passed a law like this 7, 8 years ago before TikTok exploded in popularity, because I think that taking away 170 million Americans' preferred platform, even though I think that the vast majority of those would find Instagram Reels or YouTube Shorts to be a pretty decent alternative. I'm seeing a lot of yeah. So.
It seems that those are the fighting words that are going to get
Yeah.
the crowd
Well,
coming after.
of
Suddenly
course,
there are 6 questions.
TikTok only went dark for about 12 hours because
And
we live in
people
very weird times.
already
so no
moved
one
to
knows.
they already moved to Red Note as
Yeah.
opposed to go to Reels.
That was
right?
fun. I did like that. As far as FUs go to Congress, I thought that was pretty well done.
We want our foreign adversary-controlled applications, and we want them now.
And so because of that, and here I very much agree with Anupam, I found the extent to which the government tried to argue that there was no First Amendment issue here to be I found a bit offensive. I don't like to be gaslit by my government, right? I think there is a massive First Amendment issue here, and I think actually does no one any favors. I understand when you're a litigator, you litigate on sort of the most favorable terrain before you, and I get why they did that. But on the merits, I would never say that there was no First Amendment issue.
It's just you think
here.
it's a test that can be met.
I think it's a test that can be met.
But that does put you into the factual zone that Anupam was talking about, or not?
Well, I mean, I think yes and no. So let me say a few things. Anupam is correct that these concerns are speculative, right? In the sense that the government never argued, and I suspect it didn't argue even in its classified materials, which obviously we don't have access to, but I suspect it would have been clear had they made this argument, that there was clear smoking gun evidence of whatever that means of Chinese control here. But there are 2 reasons why that doesn't, I think, bother me quite so much. The first is that in the national security context, and here I'm talking specifically about foreign actors, the speculativeness is not as fatal of a flaw, I think, as Anupam correctly points that it would be in the domestic context, right? So there's this case, Holder versus Humanitarian Law Project, which I think is the case that ultimately made the doctrinal result here, I think, ultimately very predictable, because it's such a powerful case in which the Supreme Court upheld a material support statute, so a statute criminalizing the provision of material support to terrorists, and held that that could constitutionally be applied to what would in any other context, and certainly in domestic context, be core First Amendment speech. So in that case specifically, training foreign terrorist groups on how to do nonviolent conflict resolution, right? And the Supreme Court said that because you are providing this service to a foreign terrorist organization, even though it's in the context of speech, and even though the concern here that this could somehow lead to a national security problem is very speculative. I mean, you are literally in this context helping or trying to train foreign terrorist organizations on how to do things non-violently. Even in that situation, the First Amendment will permit the criminalization of this conduct because you are in this national security context, right? I mean, there are plenty of examples about this. The very term after Citizens United was decided, the DC Circuit in a 3-0 decision written by then Judge Kavanaugh held that whatever Citizens United held about domestic expenditure on campaigns, the foreign expenditures could be prohibited, and the Supreme Court affirmed that, right? Not even just denied cert, but actually affirmed that decision, although without its own opinion. So as a doctrinal point, there really is a distinction made. Now, we can argue about the merits of that distinction, right? But just as a doctrinal point, there really is a distinction made here in the national security context. As to the other thing I would say is that it is speculative, but I don't think it's quite as speculative as I think critics of the law suggest. So on the data privacy side, I don't think the speculative argument is particularly effective. So maybe this is, maybe I take this personally, but before becoming a legal academic, I worked in the Department of Justice for several years, and I was granted by the largesse of the taxpayers two lifetime free credit monitoring subscriptions because the Chinese government stole my OPM classified security clearance data that many times. So the idea that the Chinese government might not be interested in this treasure trove of U.S. person data, I think, is not credible. And
I
to be
thought
clear,
you were going in the other direction. If you've got nothing, you've got nothing to lose. They've
Well-
already got it. so-
well, I already have it, and I don't use TikTok, but of course you want more and more information. No, to be clear, I'm not criticizing the Chinese government here, right? I certainly hope that the United States government is engaging in these sorts of espionage
You're like,
activities
respect,
as well.
yeah.
Absolutely. We're all adults here, right? There's no shade on anyone.
When are we the foreign adversary controlling their apps? That's the question.
Absolutely, and
Yeah.
if they said, right, as they do, right, we don't want Facebook and Google in our country. I mean, I don't like that, but I don't think I get where they're coming from, right? As to the content manipulation side, I think that here you have a situation where, the analogy I've used is there's no smoking gun, but the gun is assembled, it's loaded, it's on the table, and it's pointed at you, right? You're getting much closer to this nightmare scenario than you might expect. We know that the Chinese government is particularly allergic to certain portrayals of its policies and is willing to go to great lengths to change the information environment around that. There was an episode, I think several years ago, where this was during the Hong Kong democracy protests, where I think it was the GM of I'm not a sports ball guy, of an NBA team, said something nice about the Hong Kong protests. And in the process, the Chinese government basically shut down NBA broadcasts. And that's actually not a trivial thing. The Chinese market, I think, is in fact maybe the biggest market for NBA games, right? So they're willing to throw their weight around. And as to the question of, well, would the Chinese government essentially burn one of its own companies to further its geopolitical ambitions? Because of course, that is what would happen if the Chinese government did try, I think, in a very heavy-handed way, to force ByteDance to manipulate the TikTok algorithm. People wouldn't use TikTok anymore, or at least I would hope so. There are many examples of this. At some point, Jack Ma, the Chinese billionaire, founder of Alibaba, he said something pretty milquetoast criticisms about Chinese tech regulation, and he disappeared. He just disappeared for several years, right? And in the process, Alibaba was basically sold for parts. Now he's back, he says nice things, it's all good, everyone's happy. But to me, the means and the motivations and the capability is all there. And so then the question becomes, and to be clear, I've never thought this was like an open and shut case, right? I've really enjoyed sort of sparring with Anupam over the last year because this is such an interesting and difficult question. The question becomes, as sort of the national security people that I used to work with would say, we want to act to the left of boom. That is the line. So how close to boom are the courts going to require the government to get? And I think, especially because there was this data privacy justification that allowed the court, no, not interested in the DC Circuit, but allowed the Supreme Court to duck what is unquestionably the harder First Amendment question about content manipulation. I think the court said, look, we're not going to substitute our judgment for that of Congress. Now, I will say, and I hope we talk about this a little bit at some point, the last month, which has truly been absolutely wild from the perspective of executive power and
let's be ready to get to that.
Yeah.
One more reply from Anupam, and I'm particularly curious if you accept, as it seems both of you do, contrary maybe to some of those 12 judges, that this is subject to a First Amendment test appropriately, and now you just disagree on whether the factual predicate needed to pass the test has been met. Anupam, are you saying that this is not something that would be resolved once and for all, that it is possible that that gun on the table could be pointed or fired or something more could happen that would then have you say this is a valid law under the First Amendment?
Okay, so I'll address that, but let me just quickly pick up 2 points that I've made before that I don't want to neglect. So you asked, when are we the foreign adversary-controlled application? Most of the time. Most of the world uses American apps. It's, despite TikTok being the one
So just basic
outlier.
fairness requires letting the Chinese government have one shot.
Well, and watch the German elections yesterday. We may be seen as the foreign adversary for Germany. And so, boy,
Yeah, that's a bummer.
and the Europeans have not moved to ban TikTok, right? So, except Albania for a year, et cetera, et cetera. So,
I just love how you wrote off Albania. They don't count.
It's a very complicated political situation in Albania, and it's for a year, and there's all this kind of domestic. The opposition party says it's just trying to suppress opposition, et cetera, et cetera. So, but the European countries have not moved en masse to ban TikTok because they have faith in regulation. What we did with the TikTok law is said we cannot regulate TikTok. There is no way to safeguard this app. We have thrown up our hands. There is no way to secure this app at all. The only thing we can do is compel ownership change. After the ownership changes, anything can happen. You're unregulated, just like everything else. Your content moderation can be whatever it is, et cetera, et
So is this
cetera.
kind of like a less restrictive means analysis kind of thing of the First Amendment?
So I think there are clearly other alternatives which are reasonably available to achieve these compelling interests. And I agree with Alan that these are compelling interests. We certainly don't want to have massive surveillance of the United States by the Chinese government, which clearly we've seen the opium hack. But what he didn't mention was that the opium hack wasn't using Chinese-owned facilities in the United States. The Salt Typhoon wasn't using Chinese-owned facilities in the United States. Ownership wasn't the key. It was they were infecting, or they were using malware, they were using 0 days, they were doing all the other things that while Congress was focused on TikTok, and by the way, I don't know if you've ever watched the memes at the very end thanking their Chinese spy. Many of the TikTokers in the room will have seen the memes on TikTok thanking our Chinese spy for giving us the best cat videos or the best cooking videos, et cetera. And some people suggesting that they're moving to China, others just moving to Red Note, which is literally Little Red Book in China, and moving to there.
But wait, I'm just trying to know how that's making your case.
So I think essentially that the United States gave up focused on ownership as opposed to the reality of what's happening throughout the landscape. So imagine the
But if the United States had tried to say, all right, you don't have to divest, but you're not allowed to have videos that extol the virtues of Maoism, wouldn't that be a dead reckoning First Amendment violation?
Yes, absolutely. But
Well,
I think
it
that's
seems
what
not less restrictive then.
Well, but it would be not less restrictive for the espionage argument. And I don't think there is, because this was a duly motivated law, which the Supreme Court, and I'll just show, so here is a slide showing, what the TikTok bill is really about, according to a leading Republican. And he says, but I actually think the greater concern is propaganda. And you see Mark Warner, you see the other congressional House co-sponsor, Krishnamurthy, saying it was the content, dramatic differences in content. So this is rife throughout the whole debates. And the Supreme Court rewrites this history, imagines a counterfactual, and says Congress would have passed it nonetheless. What we see is Mike Gallagher a week ago saying, asked by Mark Warner, hey, tell us the truth about what the real story of why this law passed. And he says, well, the bill was still dead until October 7th. That's what he says. That's his explanation. So this is a bill designed to focus on content, and the Supreme Court's effort to rewrite this bill as one that was focused on espionage concerns, that wasn't the concern of Congress that got this bill over the finishing line. So I think we should be careful of that. The other thing about ownership here is that the NBA willing to throw its weight around, well, there are lots of companies who are subject to Chinese weight. If we're worried about Chinese pressure on companies as the modus through which China can exert its will, well, X might be a prime target in that case, because if you look at Elon Musk's empire, it very much depends on the Chinese.
But that's presumably for the purpose of an ad absurdum argument, rather than to say, so long as you go after X as well, you'd be on firmer ground.
So my argument here is that this is a constitutional decision that will reverberate for the next century. Where this case cites cases 100 years old. This case cites cases, the key cases, I already cited one, Lamont. O'Brien is another one, 50 years old. Okay, this case will reverberate 100 years from now. And so ad absurdum, ad the future, embarrassing the future, I think is exactly what we found ourselves in.
So let's turn to Alan's observation that since the Supreme Court decision came down, finding that it was okay under the First Amendment to have passed the law, things have gotten, how did you put it, weird?
Yes, I do most of my kind of more policy writing for Lawfare, and I've been writing sort of a piece a week on this, and I'm just getting more and more unhinged because the landscape is becoming so much crazier.
So give us the quick sketch of what happened.
Yeah, so the law is enacted in early 2024. It has a 270-day clock. So ByteDance gets 270 days to divest TikTok, or the law goes into effect. And the way the law goes into effect is, although it's obviously targeted at TikTok, it's enforced against TikTok's US tech servicers. So Apple and Google, who run the app stores that TikTok is distributed on, and then companies like Oracle and Akamai, who do the cloud service and content delivery networks. And they're the ones who are punished by it, up to injunctive relief, and in particular, a fine of $5,000 per user who accesses TikTok. So you do the math, right? That's like nearly—
I can see the new subscription coming out for it that's a little pricey.
Yeah,
Yes.
right. I mean, that is nearly $1 trillion in potential liability. So the law is supposed to go into effect, and I think this was just coincidental, on January 19th, the day before Trump is inaugurated into a second term, which is very inconvenient for Trump, but, you know, dem apples. It's how it works. And so amazingly, what happens is as the law goes into effect, everyone starts getting cold feet. So Trump has come out against the law, although that is after having tried to ban TikTok himself in
By
his
executive
first
order.
term. Exactly. And that was struck down on statutory grounds because the courts found that he exceeded his authorities under IEPA, the main emergency economic statute. But for whatever reason, either because he discovered the light or because some of his big funders were themselves ByteDance investors, he then turns around, or just really doesn't like Mark Zuckerberg, he turns around and supports TikTok. So he's been banging the drum about how he's going to save TikTok. But of course, right, I mean, the law goes into effect when the law goes into effect. As law goes into effect, Biden, right, starts saying, I don't know, I don't really want to enforce this, right? I'll leave this to Trump, which is, again, not how the take care clause works. We have one president at a time. And then Congress also starts getting cold feet, not just the Republicans, who presumably don't want to cross their dear leader, but also people like Chuck Schumer, who starts worrying about, well, obviously it's a big national security threat, but the influencers. Will someone think of the influencers? Right? This is when I begin tearing my hair out. Nevertheless, the law goes into effect on the 19th, and TikTok goes dark because everyone pulls the app from their services. Then, this lasts for less than 24 hours. On the evening of the 19th, TikTok comes back online because Oracle, it's still off the app stores, but Oracle and Akamai have been told, not by President Trump, it's the 19th, by the Trump campaign, that it's okay. Now, what it's okay means, given how clear the law is totally unclear. But TikTok comes back online, and then shortly after he's inaugurated on the 20th, he puts out truly a remarkable executive order, right? And if you're sort of an executive power person like me, I mean, it is an incredible document because it says, we will not enforce this law for 75 days. Where the 75 days comes from, just totally invented out of thin air, right? And not only that, I'm going to order my attorney general to send a letter to all of these companies saying, you will not be violating the law that you are clearly violating if you provide services to TikTok, and you will not incur any liability that you will clearly be incurring by providing services to TikTok. I mean, it is a remarkable— Unitary Executive doesn't even begin to cover what is happening in this document. And amazingly, this apparently was good enough for Oracle and Akamai. And what's amazing—
And do you think the GCs there had to think about it?
God, I hope so, right? Otherwise, like, what are these
You
billable
think they
hours
figured
for?
they might have an equitable remedy if they
Well-
rely on the letter and then the government comes after them and says, JK?
So they might, and in their
Trying to
in
use some
fairness,
TikTok speech
and
here.
in fairness, this did come up very briefly at the Supreme Court when Justice Kavanaugh suggested this right before Justice Sotomayor brutally subtweeted him. My God, I have never heard anything like that. When Justice Sotomayor just went, I don't think we should be talking about the president just not enforcing a law. That seems really bad. There's a very complicated doctrine around what's called estoppel by entrapment, about when you can and cannot rely on these kind of non-enforcement provisions. Generally, the courts are not big fans of allowing the president to provide this kind of relief because that would really screw up the separation of powers. And especially if you're a very sophisticated party like Oracle and Akamai are, the courts don't really feel too bad about denying you this relief. But what's interesting here is that the way that Oracle and Akamai work, because it's a per $5,000 per user fine, they basically get all of their liability very quickly. Because if 100 million people jump back onto TikTok on the 19th because they're very excited to get back on, that's it, right? Now Oracle and Akamai have...
Anything more is just YOLO.
Exactly, right? And this allowed me to, and I've been waiting my entire career to do this, include my favorite line from all of Shakespeare in my writing. This is midway through Macbeth. Macbeth is sort of in the middle of his killing spree, and he has a pang of conscience, and he says, I am in blood stepped in so far that should I wade no more, returning were as tedious as gore, right? In other words, yeah, I might as well just cross this river of blood at this point.
I'm waiting to see the internal GC's memo that quotes that.
I hope
yeah.
so, right?
Yeah.
And I think that's what that's the situation. Once these companies, right, and then apparently Apple and Google got that long-promised letter from the Attorney General a few weeks ago, and again, it's totally unclear what that letter could say, but it said enough that now TikTok is back on the app stores. And so now that these companies have incurred, in the app stores case, tens of billions of dollars, and in Oracle and Akamai's case, a company ruinous, right, probably $500 billion liability, right? Now they might as well go full on, right? And now we have this nightmare scenario where the president of the United States has an incredible amount of blackmail over these companies. And I will say, I did not have this on my bingo card.
Uh-huh. So, Anupam, I imagine it could be entirely consistent with what you've expressed so far, that once the court 8-zip rejects your read of the First Amendment, despite your extremely well done amicus brief.
9-zip, but who's counting?
Sorry, 9-zip. Which one was I forgetting? Anyway, 9-zip. I could see you saying, well, now that that is the ruling, it seems troubling to you, as it does to Alan, that everybody is somehow pretending it didn't happen by Alan's account because it would be inconvenient. But I don't know. Are you figuring, no, this is exactly right. The court came down with its decision, but let's not enforce it.
So let's rewind to April 2024 when this law was passed. The members of Congress insisted this wasn't a ban. This was a divestiture order.
With a remedy of a ban.
Yes, the ban was just to make the divestiture happen. Well, Congress played chicken with TikTok, and Congress blinked, or the government blinked, not TikTok, right? The ban went into effect, and then you had Donald Trump coming in to unban this. So in other words, Donald Trump is actually, in some sense, taking care of the law. This is the take care clause is a very complicated piece of.
Can you unpack how taking care of the law? Is it that it's like too vulnerable to be taken out of its crate? So we're just going to take care of it by.
So, just a reminder that a decade ago, exactly, like 11 years ago exactly, Obama extended the congressional deadline for Obamacare, for the employer mandate to kick in, by 1 year, despite the statute literally saying that was not available, despite people in Congress trying to extend this and failing to
I think that could sorely affect his reelection prospects.
So we have seen a number of times where the president, trying to effect the purposes of the law, has to modify the law to achieve its goals.
So wait, you're saying under the take care clause, the president can modify laws?
So I think the question here is it's complicated. And by the way, these are the GCs of the world's biggest companies that have made the decision to expose themselves to this ruinous liability. So I'm not alone in thinking that there is this estoppel by entrapment question is serious. Solicitor General Preligar said as much. She seemed to be siding with the Apple and Google and saying, in anticipating exactly this, and saying that she literally said there would be a due process problem if there was a prosecution after a non-enforcement letter. And it would raise this entrapment by estoppel.
But how does
question,
it,
estoppel by
how
entrapment.
does it save the purpose of the law to eliminate its remedy? How does that speed along a divestment?
Well, so if you ban this TikTok and then hope to revive it through a sale, you've suddenly made TikTok a much less valuable commodity. It's a lot harder to sell when you've totally destroyed it. And so there's no reason for ByteDance to sell something for a pittance. ByteDance, the latest valuation round is something like $400 billion. Frank McCourt, who is funding stuff here, is putting up $20 billion. That's the number he's floating.
Which sounds like it'd be easier to buy if it was worth less.
Yes, it'd be easier to buy, but you'd also have to have a willing seller. And ByteDance, one of the assumptions here is that ByteDance would sell. Remember when Google left China, it could have sold Google China. When Facebook could sell Facebook China, Twitter could sell Twitter China. Yahoo did sell Yahoo China, and et cetera. So there's lots of different things that could be done, and we don't think that's a fiduciary. So all these questions have been raised about fiduciary duties, et cetera. I don't think it comes anywhere close to violating the fiduciary duties to shareholders to not do the sale. And I think that's the bad assumption of Congress in April 2024.
So last question before we open it up to see if there are questions from the audience. We're approaching the 75-day mark. What happens next? By your account, Anupam, does it just mean that the president could just have another 75 days or just say never? How about never?
He could borrow President Obama's one-year approach, perhaps. But I actually think that better, if I were in the White House counsel's office, I would use IEPA, and I would say you have to keep the lights on at TikTok, because otherwise people will move to RedNote, a really Chinese app, and we've seen that before. I would use IEPA as the basis of an executive order keeping the lights on.
Uh-huh.
I think he'll just keep the 75-day extension and probably at some point drop the fig leaf of the 75 days being that meaningful and just say, I just don't really want to enforce this because l'état c'est moi. I mean, I don't know, right? Because of whatever new Article 2 theory that I've come up with.
Well, how about this Obama example? What about Obama doing the year extension?
I don't think that's so great, right? I mean, I think if we've learned
I love
anything,
how you whispered.
I mean,
He's not here.
Yeah, right, fair enough, fair enough. I mean, I think if we have learned anything, it's that the one-way ratchet of executive power and the ability to rewrite laws because of aggressive purposivist reading has some serious downsides.
And prosecutorial discretion sort of thing, either literally or by metaphor, does that help us?
So, I mean, as a doctrinal matter, prosecutorial discretion is extremely broad. The doctrine there is quite complicated. There are some circumstances in which the courts will require the executive branch to take certain actions if it is unambiguous in the statute, that you have standing issues and how to deal with that. I'm here not making a sort of narrow doctrinal argument about whether or not someone can march into court, right, and require the president to do anything here. I'm just saying that within the broader context, what we are seeing here, not just the non-enforcement provision, but to me what's even more concerning is the position of the large tech companies and the fact that they really are over a barrel with respect to this administration because they have opened themselves up to potentially.
You think the administration could, in some future circumstance, angry at those companies, say, by the way, you've been breaking the law that I told you it was okay to break.
Absolutely, and there would be a fight, and there would be a reasonable due process argument, right? But I mean, if you're general counsel, right, or if you're just a CEO of a publicly traded company worried about shareholder suits, is that something you really want to deal with? To be honest, what I suspect is most likely going to happen, though at this point I've completely given up trying to predict, but why not, right? Let's speculate irresponsibly and wildly, is that there will not be a divestment because it's fundamentally not in the interests of the Chinese government to do so. Trump doesn't really care that much. The status quo is great for him because now he gets to say he saved TikTok. Congress has no appetite for this. And I put a lot of the blame here, frankly, on Congress. And just as the TikTok ban was part of a kind of broad omnibus must-pass legislation, you could easily imagine throw a rider onto another piece of legislation that defangs PFACA or just repeals it outright. But at least, Anupam and I became friends over this over the last year. So it wasn't entirely a wasted effort.
So can I just say something about the Biden administration has been sitting on the power to ban TikTok, to require divestiture, I should say, of TikTok since it came into office. It stopped negotiating the national security arrangement, the mitigation arrangement in August 2022. Okay, so this national security threat that we are all living under right now, we are currently in danger, as the Biden administration told us, because the law had to go into effect on January 19th, until it told us, well, maybe it doesn't have to go into effect on January 19th, when it's about to go into effect. So the Biden administration had that power for years and sat on it. So the question now of sitting on it some more, it hardly seems like it's the exact kind of, compelling, it must be immediately done, national security threat if the Biden administration has ignored it.
Dovetails with your sense that this is the worst of all worlds. There's no material change thanks to the law, but a very bad Supreme Court opinion that could make mischief, a loaded gun, as it were, on the table later on. Why don't we see if there are questions? Justice Breyer, nice to see you. I don't know if you have thoughts, and Professor Lessig.
The question that I have here is maybe it would have been 8-1. Maybe it would have been. I don't know. I think it's a fairly tough case. But, the obvious thing, I thought there was a case called Kleindienst versus Mandel, where some people wanted to hear a communist, and Francis Knight wouldn't let them in. And the First Amendment did let the communists in. Why? They didn't mention it. Then, so that's minor. Major is this. Where does this come from? I mean, is it that the Congress can do anything during security? They say security can do anything under the First Amendment? Woodrow Wilson might have thought so, but not since then. What is it? I mean, they say, you say, oh, they're spying on us. Okay. I say, spying? I don't like that. It sounds bad. Have a law against spying. I mean, how do you pick one company? What's the theory? You pick one company that may be spying, but you don't have a law against spying. So why isn't that? Or maybe they broke the law. Then, or maybe it's in a bill of attainder. Or where did this come from? So on the basis of what I've heard, I make one conclusion. I haven't read the case carefully enough, because when I hear about it, I have all these questions pop into my mind. So what do you think? I mean, have a law against spying if they spy. I mean, I thought the purpose of the First Amendment was to let me hear what I want to hear and let me say what I want to say.
Yeah,
Okay.
I mean,
but is that so? What we're this law? This isn't about whether the president's doing blah, 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 or what. Oh, I don't even know what Oracle is. It's some kind of thing. It was in Delphi, I think. But okay. But what? What's the answer to the obvious thing? Law against spying, fine. Law against you, because 160 million people want to hear you? No. What's the answer to that?
So I think the answer comes from, yeah, so just briefly. So first, I do think it is a hard question, and I think, had the court, I think the court was 9-0 because they've only focused on the data privacy rationale, and had they focused on the content manipulation rationale, I think Justice Gorsuch's concurrence suggests strongly that he would have dissented in that, and so it would have been an 8-1 decision at least. In terms of where this comes from, I think it's a combination of a couple of things. First, I think part of it is a truly long tradition of foreign ownership restrictions on U.S. Communications platforms. Part of it has to do with broadcast scarcity, but I think you could make a decent analogy to attentional scarcity as the replacement. When Rupert Murdoch wanted to buy the stations that ultimately became Fox News, he had to renounce his Australian citizenship and become a United States citizen. And we've had these kinds of laws for well over a century, and I don't think they've ever been seriously challenged. I don't know of sort of, certainly not Supreme Court precedent on this point. And then as to sort of the question of, well, can Congress just announce, hey, there's a national security concern, therefore we strip away these First Amendment protections? I mean, I certainly think that there's still some level of scrutiny, but I think, again, doctrinally, especially after opinions like Holder versus Humanitarian Law Project, which...
Yes, exactly.
Hey, if you can ignore the law, you can ignore an opinion you don't like.
I'm
either.
just a consumer of these cases. I think the doctrinal landscape becomes, as I'm sure you can appreciate, much more complicated.
So just became a Holder, which was wrongly decided, but even just taking Holder on its face, Holder was talking about a law that wasn't focused on speech suppression. The law was overall content neutral, and it had an incidental effect on speech. I think, as I said, I think it's wrongly decided but like O'Brien, the Selective Service Registration Act case, that law was a content neutral law. As I've said in this case, again and again and again, and the Supreme Court just ignores the fact that this was intentionally singling out speech apps. It limited itself. When it said foreign adversary-controlled application, it was only foreign adversary-controlled speech applications, okay? It was a speech suppression law through and through, and the court just ignored that.
Lessig, and I know we're running low on time.
We're running low on time. Alan, I completely agree with your account of the Supreme Court doctrine and why, in fact, you can do something against this foreign company. But shouldn't there be an exception when it is absolutely clear this wasn't about Chinese speech? It was about Palestinian speech. I mean, that's the whole point of Anupan's reference to Mike Gallagher acknowledging that it was Congress recognizing all this pro-Palestinian speech was now flowing across American border, and therefore we had to stop it. So shouldn't the doctrine be cabined by saying that if they are so sloppy as to admit that they're plainly doing it because of the speech that's being uttered, then it violates the First Amendment? But then, Anupan, I want to really push you on the idea that we would equate these Chinese pamphlets in Lamont to the manipulation machine that TikTok is. The idea that these are the same thing just seems completely naive to understanding what the technology is. And doesn't the doctrine have to begin to be more realistic about the difference between what TikTok is, or what any of these social media platforms is, and the kind of ancient doctrine of Chinese propaganda?
Yes, I'll go quickly. So those quotations that Anupam put above us, and I can't believe you would do that to me. We were having such a nice, and then you brought PowerPoint into this.
He brought speech.
You brought PowerPoint into this. Those aren't great for me. Look, you got to concede where you got to concede. Those aren't great for me. I will say two things. One, I will say, there's a way of spinning that and to say, look. What October 7th was it was an example, right, that brought into focus the kind of influence that these social media platforms can have, and really we're looking forward into a much broader array, and of course the law itself is not about pro-Palestinian or anti-Palestinian speech, it's much more general. It's not a great answer. I get it, right, I'm not so naive. I'd say the bigger problem is how do you operationalize this kind of concern, right? Obviously this question of intent, in legislative action is an extremely tricky one. There is a I know it when I see it kind of element to it, but Congress is also a they, not an it, and trying to come up with a doctrine, right, that you can actually operationalize, where you look at this statement, you look at that statement, but you compare it to the law, which is more neutral, and you compare it to the possibility of why, and you're going to make Congress redo its work, and really let's kind of think game theoretically about this. Now you're just going to get Congress not to be better motivated, but actually, if anything, to just lie about their motivations more. How you operationalize that doctrine is extremely complicated. So I'm not surprised the court didn't go there. But no, I don't love those quotes either.
Just quickly.
All right, very quickly.
Very quickly. So pamphlets gave us the United States, gave us the independence of the United States. So pamphlets can be very powerful indeed. The Whitney v. California case is about the Wobblies. Lamont is about the concern that Chinese or communist propaganda was going to take over the United States, convince Americans to unite across the world as workers and throw off the masters. So I think we can worry about the power of propaganda over history, whether it's a pamphlet or these content manipulation machines.
I think of the empirical studies that have shown that people would pay a lot of money not to be deprived of TikTok, and they would pay even more money to make TikTok not exist anymore. There's a kind of weird paradox there. But this is the kind of conversation that is indeed priceless, and I think we are so glad it came about. And it's truly in the spirit of the Rappaport Forum to see a spirited back and forth on these topics. Scholars of the world unite. Thank you all for this conversation, and I hope we can continue it as we go. We'll see you back in the balance of the 75 days. Cheers.